Good morning, everybody, and welcome back to your Lunch Break Live. My name is Ivana, if you are new here. And this has been a long week. It's been a long newsy week. And to kind of wrap things up for our week, I thought it would be a really interesting conversation today. I am joined by Birmingham area attorney Jack Sharman. Now, Mr. Sharman works with Lightfoot, Franklin and White, and he is a partner there. And Mr. Sharman has a lot of experience in election law. He actually had an experience working in the Bush-Gore recount 20 years ago. Mr. Sharman is here today to kind of recount that experience for us and also answer some questions that I know a lot of you have regarding this 2020 presidential election and how things might play out here. I know we've all been waiting on a result for several days, but it is hard to deny that there is a lot of legal aspects to this election and before somebody can be declared as this winner. So, Mr. Sharman, thank you so much for coming on today and for telling us about your experience 20 years ago.
I'm glad to be here. Hope it's helpful.
Well, let me first just get started. I know we've got some good questions that we got from some of our readers and viewers, but first, let me just ask you to tell us how you got involved in the Bush-Gore situation in 2000 and what your role was in that recount.
Well, as a lot of your viewers and listeners may recall, the election between Governor George W. Bush and Vice President Al Gore came down to really one battleground state, Florida, and the initial results were so close that automatically under Florida law a recount was required. But then there was litigation brought by both sides, ultimately lawsuits about both how those recounts were to be conducted and when and how they could be done before the federal certification deadline in December. That issue ultimately went to the Supreme Court, which decided that the rules that had been imposed by the Florida Supreme Court violated equal protection under the U.S. Constitution, thus effectively ending the election and causing George W. Bush to become president. I was one of lots of lawyers, Democrats and Republicans, who were shipped to Florida to be essentially not only observers but participants in the recount that varied from county to county in Florida, depending on how counties had run their voting systems. Some of your viewers and listeners may recall the phrase hanging chads, which were little pieces of paper that remained stuck to a paper ballot, a ballot that the voter was supposed to mark his or her preference for the candidate by pushing through, creating a hole that could then be machine read. Many voters did not push through all the way, or they pushed more than one part of the paper, which caused multiple holes to be created. And so there were lots of problems and issues about determining the intent of the voter, which is the whole purpose. In Volusia County, where I was, they used bubbles, much like one does in Alabama, to sort of fill in the bubble. But there were similar problems in discerning voter intent going ballot by ballot. A voter might, for example, fill in a bubble, cross it out, fill in another one, sometimes fill in yet another one, sometimes fill in a bubble and then make a check mark in another bubble. And on one occasion, we even had a voter who filled in every bubble for every candidate on the entire ballot. There was considerable discussion at our review group, which was, like every other review group, composed of a county employee, in Volusia County from the probate office, a Democratic lawyer and a Republican lawyer. The county employee would pick up the ballot. We would all review it, hopefully agree as to the voter's intent. In the example I just mentioned, we had a rather unusual discussion about what this voter meant to do. My counterpart said it was a protest vote. I agreed. It's clearly protesting something, but we couldn't discern what the voter meant, and in that case, that ballot had to be discarded. It's an unusual and rather arduous process, and I don't really recommend it.
Yeah, it does. It definitely does not sound like my idea of a Friday night fun going through all of those ballots. And we should note that at least on Alabama's ballots, that's why they tell you at the very top, fill in your bubble completely. Do not exit. Do not check it. Fill in that bubble totally. And there's even a line on there. If you stole your ballot accidentally, then please ask for a new one. That's something that is at the top of all of our Alabama ballots. But I think that experience is so interesting, and I would love to hear your take on something that we've heard from people during this campaign season and during this week, rather. And does this election, does this 2020 presidential election, in your mind, do you see similarities between Bush Gore in 2000, or is this kind of bringing up those memories for you, or do you think this is a totally different situation?
It's somewhat similar. There are obviously quite thin voter margins, at least at the moment. There are some thin margins in important states, and not that all states in the union are not important, but in reality, for this discussion, there are only a handful of states that are going to be at issue for this kind of concern. That those are going to be battleground states with a meaningful number of electoral votes at stake. So it's certainly similar in that regard. There has been more, not less, pre-election litigation than there was in the events leading up to the Bush-Gore decision. As I'm sure you know, I mean, there has been a litigation and lawsuits really since the spring about various aspects of the electoral process. One thing that I believe is different this year as far as the litigation goes is the disputes about the Postal Service, issues that were of course raised because of the unusually and perhaps unprecedented ultimately amount of early voting and absentee voting. So there was and still is litigation regarding the post office. Judge Emmett Cox, a federal judge in Washington, has ordered the post office today, and I don't know if he put a deadline on it, I don't remember, to do sweeps in North Carolina and Pennsylvania twice a day for missing ballots. So it's very similar, but there are a few differences. But I think people should need to keep in mind that there needs to be ultimately, for any of the litigation to matter, a path to the Supreme Court, at which most of the lawsuits now probably do not offer. The ones that are in Pennsylvania would be the most likely candidate for that, but in reality, if the margin is not sufficiently narrow, or if Pennsylvania itself does not end up being decisive, even there that would be foreclosed, and I think in general, despite what political partisans say, the Supreme Court would rather not decide this election.
And, we'll note here, not only do you have experience in that Bush-Gore recount 2000, you have been practicing law for quite a while. You have a lot of experience there, and especially in the federal courts. I know over covering courts for the years, I even covered some cases you were on in federal court. So you are very familiar with that realm. And I want to use that to go into a question that we have from both from Anna and then one from Taylor. And this is from Anna. And she says, do you think that we could see this race go to the Supreme Court and be another one like 2000? And again, from Taylor, if this does go to the Supreme Court, could this be the end of the electoral college system as we know it?
I mean, this is a little bit of tea leaf reading, but, as I alluded to a moment ago, I think that it's unless we have a close to perfect storm involving Pennsylvania, I think it's more likely than not that there would not be a repeat of the Bush-Gore scenario, which again was a recount scenario, that is after the fact. Many of these lawsuits that have been filed by both Democrats and Republicans deal with the issues before the fact. What are the rules? Were the rules changed to close to the election day? How are the rules being implemented? If the rules provide for some sort of observers, are they being allowed access? That was the issue in the Philadelphia case, which has been essentially resolved by agreement, by negotiation. So I think it more likely than not that there will not be a Bush-Gore kind of repeat unless we find ourselves again in that kind of hardcore, so to speak, recount situation. As to the second question, whether this impacts the viability of the Electoral College, I'm not a political scientist, and I'm probably not qualified to speak to that, other than to say that this is less an Electoral College issue than it is an artifact of the fact that the Constitution, the federal Constitution, places responsibility for elections almost wholly with the states or their bodies, such as state legislature, a state election board, or a state court.
I'm going to shift a little bit from the court aspect, and we've got a lot of people asking about the recount situation. We know that there are recounts expected. We know that just this morning, the Georgia Secretary of State said that the narrow margin between President Trump and former Vice President Joe Biden means that there will be a recount. We've got several people saying, look, if the votes are counted fairly, why does there need to be a recount?
In many states, Georgia's one of them, state law requires one if the margin between the candidates is sufficiently small. In other words, it's not discretionary. In other words, the legislature in that state has decided that regardless of what the race is or who the candidates are, if it's that close, then fairness, due process requires that the result be recounted so as to account for, if nothing else, human error. In other states, a losing candidate needs to apply for it. It's not automatic. But in either instance, it reflects a legislative determination in that state that if it's that close, we better have a replay.
So, and just to get you to kind of repeat that, so in a state like Georgia, there is a state law saying when the margin is this low, we must have a recount. It has nothing to do with the two gentlemen who are on the ballot.
It doesn't. I mean, it will obviously, one obviously usually would rather not have a recount, and one usually would rather have a recount. But those rules are generally of long standing, and are especially when they're statewide rules, are not specific to any individuals. But there are difficulties though in implementing them, even though they're pre-existing rules, because those statutes usually do not provide detailed guidance as to how the recount is to be done. Are there to be observers? If there are, who are they? Is there some sort of certification required? If there is a dispute about a particular ballot, how is that resolved? How is that resolution appealed from, if at all? So even though they're pre-existing statutes, unfortunately, a lot of times for the people on the ground trying to do this, there's not a great deal of guidance.
And on the flip side of that, we have people saying, look, if you are the person who wins, why would you oppose a recount other than to say, look, we think these votes are fair. Sure, if you want to recount them, go for it. Why do we see sometimes that person who wins maybe the election doesn't want a recount in that state?
Well, I mean, I think obviously the reason they don't want one is if they won and they want to hold on to their electoral victory. And that's understandable. Also, I think that there can be errors in recounts, just as there can be errors in the original count, and there can be opportunities in a recount to not only make mistakes, but to purposefully do something inappropriate. Again, I don't think that happens very often. The greater threat, so to speak, is just human error and inefficient systems. And then I think also there is value in finality. I mean, these are huge decisions, and there is some value to our public life in finality and knowing. In the Bush v. Gore situation, that was decided, I think it was argued on December 12th and decided the next day. That doesn't seem that long from election day, but at the time, it seemed never ending. And I think the system values finality. And so that's another sort of value neutral reason that a victor could say either don't have a recount or certainly have it with some guardrails that make it to give everybody confidence that it's being done well.
Well, and you talk about that long, tedious process that you were involved in a county in Florida in 2000 about taking the votes and holding them up to the light, making sure there were correct punches done in the correct way. And like you said, that doesn't sound like something, if you put politics out of this, and I know that's very hard to do, just the process is not an appealing process for most people to go through. It's time consuming, it's tedious. And like you said, this has been a long week. Everybody's exhausted, and everybody, no matter what side of the aisle, kind of wants some finality to this. But I do want to ask you about the widespread claims of voter fraud and of other inappropriate conduct regarding voting, ballots, etc. Legally, do you need to have a specific instance of voter fraud, of misconduct, to take a theory to the courts and to play that out in court? Do you need to be able to pinpoint and say XYZ happened at ABC polling location on this day?
You need to have enough evidence of at least irregularity or a failure to follow required process in whatever state or city or precinct is involved. And you need to be able to support that with some level of evidence, by affidavits, by witnesses, by documentary evidence, that would at least allow a court to consider the problem. It's not enough to say, I think there's fraud, or I sent an observer and she couldn't get close enough to even observe anything, or I heard that there was a bag of my candidate's ballots shoved in a corner of a warehouse. Usually that is not good enough, and I think we have seen that thus far in most of the lawsuits that have been brought by President Trump's campaign. They have been, for the most part, dismissed, kicked out of court, in large part for that very reason. There's just not enough there to go forward. Now, sometimes they have been resolved by just negotiation. For example, in Pennsylvania, in the Philadelphia Observer case, essentially the judge told both the Democratic and Republican lawyers, act like grown-ups and come to some sort of compromise that will, sort of satisfy everybody. And I believe that they came up with each side can nominate up to 60 observers, but they also have to stay 6 feet away for coronavirus reasons, from the person taking in the ballots. So of course that may handicap one's ability to actually observe what's happening. But in general, you have to have some legal basis, some factual basis, something you can point to say, Judge, here's the evidence of the problem, and you can base your ruling on that evidence.
Well, and I think that it's interesting you bring up that point about the observers. We know you said in Florida that there were 3 people observing these ballots per county. There was a county employee, a Republican lawyer, and a Democratic lawyer. Now, we talk about observers, though, in places like Philadelphia and in Pennsylvania. We do have to keep in mind that while right now it seems like the presidential election is the biggest thing happening right now, coronavirus is unfortunately still around. It is unfortunately still a factor in our lives right now. And I think that's a good point. I do want to ask a quick question that I got from a viewer named Jason. And Jason says, how does the change from paper to electronic ballots change strategies of these legal teams?
That's a good question. It doesn't change the underlying requirements and sort of legal structure, that we just touched on a moment ago. It does to some degree change the relief that you are seeking, because if or when a vote is machine read, there's not much to be done with that ballot at that point, other than making sure that, or confirming that the machine is plugged in and functioning as it is supposed to. Similarly, there is an issue with drop boxes for early ballots, which was something of an innovation this year, which spoke both to early voting and to coronavirus concerns. There are in many jurisdictions cameras placed on those ballot boxes or drop-off boxes, I think in some jurisdictions, President Trump's lawyers have sought to obtain all of that video. But of course, the problem is it doesn't really, unless somebody is stealing the box, it doesn't really show anything about a particular individual voter's ballot. Now, in most, and well, probably all jurisdictions, even those that rely on machine voting to a great extent, if there is a paper ballot, it is maintained. So, for example, poll workers in Alabama, when they're closing the poll, they will keep all those paper ballots and they'll seal them up and sign, seal, so that if there's ever a need again for review of the paper ballots, they will be there. So the legal structure doesn't change. Some of the mechanics and the relief you want, that does change a little bit.
Question about recounts again, and that is, I think, what in essence is a simple question. The answer might not be simple, but what is the likelihood when there is a recount of a state's vote? What is the likelihood of that final result changing or that state flipping?
It's actually very low. Recounts rarely change results.
And, I think that one thing I want to touch on here before we go, I know that we could spend a lot longer talking about this, and there's so many things to talk about. But one thing I wanted to touch on before I let you go is that there are so many people who are discovering now that each state has so many different laws regarding their elections, their ballots, their process of voting. And that is something that, again, most people are just kind of coming to terms with, because a lot of times we live in a bubble of our state. We know our state rules and we think everybody does it the same way. But can you talk about how there's no national election board or structure that has to be followed, and that is really up to the states?
That's right. I mean, the Constitution places almost all responsibility for elections, including federal elections for federal office, including elections for president, at the doorstep of the states or state entities, again, legislatures, state election boards, or county or state judges. Each state has a different way of handling that, and so we have essentially a 50-piece patchwork to run a nationwide election, and that is so for lots of historical reasons that we probably don't have time to go into now, except, of course, at the time of the adoption of the Constitution, the national government was not anything like what we all think of it as being today. So it is to those of us who are now accustomed to thinking of things in national and global terms, it is a little disconcerting sometimes to see this system. On the other hand, in general, I have great respect for and admiration for people who staff polling stations, for probate judges and county clerks' offices and local election boards who, at least in my experience, are overwhelmingly honest. They are not doing these jobs to get the glory, and they're doing the best they can, and usually actually get it right.
That's a really good point, and we should, all appreciate our poll workers and the amount of work that they are doing to make sure that our votes get counted and that our voice is heard. So, Mr. Sharman, thank you so much for your time today. I know this is going to be probably a long day for those of you that are following the presidential election and maybe even a long weekend. So I will let everybody get back to that. Mr. Sharman, thank you again so much for your time, and we really appreciate it.
Thank you for having me.
And everybody watching, thank you for your time as well. We'll see you on Monday.